You. Thank you so much. I was a little bit hesitant, quite candidly, about speaking today. The last time I spoke at a group like this about this topic was actually over at your sister church, Somerville Baptist Church. Okay? And a dear, older, sweet sister in Christ came up to me afterwards. She had known me for many years. And she said, these were her words, "Jimmy Reeves, you have not changed a bit other than that gray hair and all that weight you put on." So if y'all could refrain from those kinds of comments, I would appreciate it a great deal. I can't see my notes with my glasses on, and candidly, y'all are a little bit blurry with my glasses off. Okay, so just forgive me if they're coming back on and back off. But we're going to be talking about a lot of just really exciting subjects, dying and being in comas today. Okay, so your Saturday is only going to get better from here on out. But before we start talking about dying, let's talk about while we're still alive. That's maybe a good topic to begin with. But maybe talk about while we're still alive, but we're not able to make our own decisions for us. Okay, you've got a blue folder there in front of you. I noticed Miss Kimberly's passing out bags, so she's already upping me on the handouts there. But over on the left-hand side, you'll just see a little information. It's called Powers of Attorney Information Sheet. So let me just kind of walk you through that just for a little bit. There are two types of powers of attorney that I think everybody needs. One is what's called a healthcare power of attorney. The other is called a general durable power of attorney. The healthcare power of attorney obviously deals with healthcare issues. So you're in a bad car accident, you're in a coma, you're under a lot of medication, you can't make your own healthcare decisions. You can designate who makes those decisions for you. Okay? Many times it is your spouse or a child, but it doesn't have to be. It can be a friend or somebody in the church. I would encourage everybody to have those. If you go into the hospital, and many of you probably do, even if you just go for some type of elective type surgery or whatever, it's a pretty standard question that the admissions clerks or someone will ask you is, do you have a healthcare power of attorney? Many times they don't ask for a copy of it, they just want to know whether or not you have one. And so I do encourage you to have this. Now, the healthcare power of attorney form also has incorporated into it what are called living will provisions. So you're dealing with issues in which maybe you're just under a lot of medication and you can't make your own decisions, okay? But it also incorporates very serious end-of-life issues. Okay? Who's going to make that decision to withdraw life support if that is indeed what you want to do? Or if you don't want to withdraw life support, you can give instructions, not for that not to happen, as well. So I would encourage you to have that document, right? And to be thinking about, who's going to make that decision for you. Now, again, usually the primary agent is usually a spouse or an adult child, but again, it doesn't have to be. One of the questions I many times get asked is can I have co-agents? And the answer to that is yes, you can. All right, you can have co-agents. Just understand that with co-agents, logistically, if you've got two people listed, both of them have to either be there or be a part of that decision. Okay, and also you need to. Anytime you have co-anything, whether it's co-agents or co-personal representatives or etc., you need to have two people that can work together and get along with each other. Okay? Because if you got two hardheads that are one thinks this and one thinks that, then nothing is gonna happen. I'm going to tell you from some conversations I've had with Judge Blunt, who's our Dorchester County probate judge. She doesn't like co-anything. Right? And I've talked to her about it, and I've said, Judge, the reason you don't like it is because you're the one who's having to sit behind the bench and listen to all the arguments go back and forth, and that's exactly right. But she does raise a good point. So anytime you have anything, you need to make sure you've got people that can work together, through that process. Okay, and very important to have that. Now, it doesn't bother me as much as it did 30 years ago when I first started practicing about whether or not that person needs to be local or not. Okay. I think obviously it does help if that person can be local and can physically be there in the hospital, in the ICU room, etc. But it doesn't have to be. Okay? Technology has reached to the point now where you can pull up your phone. I've got a good pastor friend who's in the Philippines, and seriously, within a couple of minutes, I could pull him up on the phone. He probably wouldn't like that because I think it's the time difference is different, okay? But, you can pull it up, with that. It was just kind of mind-boggling. My wife has had some health issues, and back in August, Pastor, I don't even know if I told you, but she had a little stroke, and so we were at the emergency room in the hospital, and she's perfectly fine now and doing quite well, and was actually chastising me this morning because I didn't put the dishes in the dishwasher the correct way. So I think things are back to normal. I mean, Sam, I thought I'd get credit for putting the dishes in the dishwasher, okay? But evidently they're not in the right order. But anyway, so she's fine. But technology is such that the neurologist that was attending to her was physically not there. She was on, I don't even know where she was. But the hospital staff was pushing a little computer monitor around the hall, okay? And I was talking to this doctor, via this computer monitor. So technology has gotten to the point where that is not a major issue with me anymore. So if you have adult children that live in other states, I think you could certainly, list them there, okay? So that's a healthcare power of attorney / a living will. Okay? Now, I will tell you, not to confuse you, there is a separate document that is just deals with end-of-life issues. Okay? I personally don't have one of those because the healthcare power of attorney is broader and it incorporates those same decisions too. Okay? So I always get, when somebody comes in, and many lawyers will do both, and there's nothing wrong with having both. You just want to make sure that they're consistent, though, okay? And so for that reason, I always like to have one document, with things. So if you're sitting there and you're saying to yourself, Jimmy, got that checked off, I've got a living will. Well, good. Take a look at it. Is it just a living will, or is it a healthcare power of attorney? Because the living will just deal with end-of-life issues, whereas you might be under medication and somebody needs to be making decisions for you. Okay. All right. Pastor told me not to take questions in between. Pastor, I'm going to disregard your conversation. Let me just say, do we have any questions about healthcare powers of attorney? Anything right now that I can talk to you about? And I'll be around afterwards too, okay? Well, they're not disregarding your instructions, okay? All right. Okay. General durable power of attorney. That is that's the other type of power of attorney. While you're still alive, your business, your legal, your financial affairs, okay? Same scenario. You're in a car accident, you're in a coma, right? Who's gonna pay your bills for you? Who's going to talk to the health insurance company because they're claiming something's not covered, okay? Because you're in a coma. Maybe you're in a coma because the drunk driver ran the stop sign. Possibly we might need to file legal action against the drunk driver in order to access those insurance proceeds to help pay for your care, all of those kinds of things. Who takes care of your affairs, your financial, business, legal affairs? And that's called a general durable power of attorney. And I would encourage you to have those as well. Again, I like to have primary agents and then backup agents. You can have as many backup people as you want to. Sometimes people have 4 children and they just do it birth order, okay, right down the line. And they'll go ahead and list everybody just for relationship purposes, that everybody is listed on the document, okay? So, you know, you can have those also. There's some statutory changes in 2017 on general durable powers of attorney. Those are whopper of documents. Now, when I first started practicing, I can remember the older attorneys coming in to me and, Jimmy, welcome to the law firm. Here's a good general durable power of attorney form that you can use. And they were just a couple of pages long and very general, very broad, and candidly very vague. Basically said my wife can do anything I can do, or my husband can do anything that I can do. Those have caused problems because they'll have very general language such as my wife can handle all my real estate transactions. Okay? Well, what does that mean? Does that mean that she can sell your property? Okay? Does that mean that she can, you know, rent property, lease property, buy property? What does that mean? Okay? And so, you know, the man is in the coma. He comes out of the coma 3 months later, and the wife has sold the family farm that's been in the family for 4 generations. Right? And so, no, I didn't mean that she could do that. Okay? Well, so General Assembly came in and changed and said, you know, you've got to have express specific language, and if it's not in that document, then the agent can't do it. Okay? So it needs to be in that document. So as a result, the lawyers in the world, including me, starts getting concerned that one of you is going to be in a coma, your spouse is going to need to do something, and they're not going to be allowed to do it because the language is not in the document. Okay? So those documents, we just candidly, I put everything in the kitchen sink, you know, into those things to make sure that they are covered. There was a situation where you know, a lady had. The man went to the post office, set up a post office box, and for years he was the one who checked the mail. Right? Well, he's now in the hospital in a coma. Wife goes to the post office, wants to check the mail. Right? Here's my power of attorney, but it wasn't listed in the power of attorney that she could check the post office box. Okay. And so, therefore, you know, we had all this rigmarole trying to get the checks in the mail and all these kinds of things, okay? So make sure you have a good general durable power of attorney. So while you're still alive, healthcare power of attorney and general durable power of attorney, okay? And again, glad to answer questions about that, and I'll stick around afterwards, you know, with this. Now, we've talked about being in a coma. Let's talk about us dying now, okay? All right? So let's really get into the fun things about things. All right, now, before we talk about whether wills or trust, okay, and I'm going to try to talk you through both of those today. Before we talk about those, let's talk about this bad, evil word called probate, okay? And people hear that word probate and their stomach starts to, you know, to churn. Okay, and some of you in here have probated estates before. Okay, so you've lost a loved one, and you've been involved in that, or maybe you haven't been involved, but you've heard, you know, bad horror stories, you know, about that. Probate, the way I'm using the word, talks about the distribution of assets after somebody dies. That's what I'm talking about. Okay, now interestingly, the probate court just deals with what are called probate assets. Right? Now, probate assets are assets that are just in your name, and they're not any kind of joint account, or there's no beneficiary to them. Right? So let's just say a bank account. You have a bank account that is just in your name. Right? You die. That's a probate asset. It was just in your name. We got to go through the probate court to distribute out that money, to figure out who's supposed to receive that money. Whereas you have a joint account, you and your wife, you and your husband, whoever, right? And you die, that is a non-probate asset. Why? Because it has somebody else's name on that. Okay? And so I like to have, as much as possible, your assets set up as non-probate assets. Okay? Now, again, I deal with the probate courts on a daily basis, and candidly, I wouldn't want to have their job. They deal with families in conflict every single day, right? But I'm just going to tell you, to the extent that we can keep you out of probate court, that's what we want to do. Okay? We want assets going as quickly as possible, to you. So your next sheet over on the left-hand side is understanding non-probate transfers. Okay? And so I just want to kind of walk you through some of those. Understanding non-probate transfers. I would encourage you to have joint checking account, joint savings accounts, with things. Now, husband and wife, husband and wife, y'all said I do, and you're married, and to me, you're one group, okay? I'm not a believer legally or spiritually in separate accounts, right? And again, maybe you disagree, and that's okay. You can fire me, all right? But I believe that things ought to be combined. Now, there are different ways of holding accounts. One, the most simple and the easiest, most common is just a joint account. That's how my wife and I hold money. Okay? I can go to the bank, I can withdraw all the money. She can go to the bank, she can withdraw all the money. Okay? All right? So there's some pros and some cons on that. Okay? All right, with that. Sometimes people, especially after the death of a spouse, will ask me about, should I put my child on a joint account? You certainly can, right? Certainly helps out a great deal. Have adult child on a joint account. That could be very helpful. Just understand, okay, when you pull it up online, okay, and they've gone on and withdrawn $5,000 from your account, and you go to the bank and complain, the bank's going to say, it's a joint account, okay? They have the right to pull out that money. Here's the other thing on joint accounts. After you die, the money goes to whoever is on that account, okay? All right, so here's the scenario. Husband has died, you have 3 children, right? One of the children is local. So you put that local child on the joint account. Right? Your will says, whenever I die, everything gets divided 3 ways amongst the 3 children. Okay? That's just for probate assets. Okay? Your joint account with your local daughter is a non-probate asset. That money goes to her. Okay? Now, your intent was that once you died, she would take that money, right, and divide it up amongst her other siblings. She doesn't have to, okay? And I've seen that cause some problems. So just be careful about, putting, joint account. Again, I'm a believer in joint accounts, but just be careful about who you put it on with. There's another type of account called a payable on death account. You can talk to your banks about these. Payable on death account is simply that. They don't have access to the money while you're still alive. They only have access to the money after you die. Okay? So it doesn't, if you're in a coma, for example, they're not going to be able to go to the bank and write a check unless you have that general durable power of attorney that you can rely on. Okay? But then again, after your death, the money automatically goes to them. Let me tell you that those are two different types of non-probate transfers. One of the biggest glitches that comes up when people pass away that their family has to deal with are cars. Okay? Cars, boats, RVs, anything with a title to it. Okay? In South Carolina, I like to see husband or wife own the cars, okay? Not husband and wife. It's also very common that the husband owns his car and the wife owns her car. Okay? Right? So whenever one of them die and that property is just in their name, that's a probate asset. Okay? We got to go through the probate court in order to get that transferred over. Whereas if it says husband or wife or mother or daughter or whatever it is you want to do, then upon your death, they don't have to do anything with it at all. They can it just takes one of them to sign it. Now, if you take a look at the title to your vehicles, boats, whatever, cars and RVs, you do that through the Department of Motor Vehicles, okay, DMV. I think boats, you run that through the Department of Natural Resources, DNR, okay? But just take a look at it and make sure that it says or. It's not going to surprise me if you own your truck and she owns her car, okay? So what the answer to that is take your title down to our friendly DMV office, okay? Stand in line there for 30 minutes, okay? 45, hour and a half. While you're doing that, you tell them about the great church that you're going to, okay? All right? Those people got to stand in line too, right? They can't go anywhere, all right? Just talk to them about the Lord, amen? Okay? All right? Just tell them about things. Use that hour and a half, you know, to God's glory with that. I tell you, can I preach just a second? Okay. I got talking about the probate court. Frankly, I got a little aggravated, and over the holidays, and I didn't really like the way the probate court was doing something, but that's okay. They're the probate court, and I'm not, and so I ended up saying, you know, over the holidays, I said, you know, I think I just got to take this to the probate court, okay, and I was just a little exasperated, all right. I'm just going to have to physically take it up there. I got to drive to St. George, 45 minutes. I got to drive up there. So I drive up there, and lo and behold, there's a line, believe it or not, okay? There's a line. So I'm standing out there in the hall, and I'm just kind of going, oh, goodness. And I don't want to be there to start off with. I'm kind of in a bad mood. You know, only thing I want to do is just deliver these documents, get out of here, go about my holidays. Old man walks up, and he's standing in line too, okay? You ever tell when somebody just wants to talk, okay? Can you just tell? He just wanted to talk, right? I didn't want to talk. I was in a bad mood. I didn't want to be there. Okay? I didn't want to talk, right? So he starts talking, and I'm polite, okay? I'm polite. I am, all right? And I'm professional. I talk a little bit. I get my documents delivered. I'm out the door. I'm driving back on 78, and I'm going to tell you, the Lord spoke to me, okay? He said, Jimmy, you missed it. You missed it, okay? This is what you missed. I sent you to the probate court for a reason. Okay? It wasn't to deliver your documents. I sent you in order to talk to that old man. You see that? So when you go to the DMV and you're standing there for an hour and a half, you know, learn from Jimmy Reeves. Don't be in a bad mood. Use that opportunity to fulfill the Great Commission. Amen on that? Amen. Okay, going back to can I have an extra 5 minutes since I preached? Cars are a big one. Title to property, real estate. Okay. You and your wife own a piece of property. You've owned it since the 1970s. I listened to this just this week from a lady. I've owned that property. My husband and I bought that property in 1977, okay? And now the probate court is telling me I got to probate that property. My name is on it. Since my name is on it, doesn't that just mean that whenever he dies that I become the owner of all the property? And the answer is maybe, right? It depends on how the property is titled, okay? If it says husband or, it says, actually, listen to this. It says husband and wife as joint tenants with rights of survivorship and not as tenants in common. That's a legal mouthful, okay, that says that upon the death of one, the property goes to the other. Okay? If it just says husband and wife, you're going to have to probate the 50% interest. Okay? So take a look at the deed to your property. Okay? That's another one. You need to have, I'm going to let Mr. Jeff talk about this, but you need to have beneficiaries on your life insurance policies, okay, and contingent beneficiaries as well, okay? You don't want that money being paid through the probate court, okay? Because if a life insurance company, somebody dies and there's not a living beneficiary, they don't know who to pay the money to. Right? So they're going to pay the money into the estate. All right, so now we're going to have to probate that $100,000 or whatever it is. Make sure you have beneficiaries listed. And whenever you set those up, your beneficiaries then might have been perfect, okay? But you got to make sure you update those, okay? You know, with things. You know, son goes off, joins the Army. He's a World War II, joins the Army in World War II. He buys a life insurance policy before he gets shipped out. Who does he name as the beneficiary? He names Mama as the beneficiary. Why? Because he's not married. He doesn't have any children. That's who it goes to. He never changes it. Okay? He gets married. He has children. He lives a long life. He dies. Okay? Now, who does the life insurance company pay the money to? Mama. Okay? But Mama is now dead. So now we got to go through all this rigmarole trying to get this money. So check your beneficiaries on that. Amen on that? Okay. Is that okay for me to say amen on that?
Yes,
okay. Okay, good. All right. Non-probate transfers. I can talk some more about that too, but I'm running out of time. Let's talk about your will information sheet. Will, very common. We do them all the time. When you're doing a will, think about who's going to be your personal representative. That's the term we use in South Carolina, personal representative. Same thing as executor or executrix. Okay? Who's going to handle your affairs afterwards? Number two, think about your distribution. Who's going to be receiving your property, okay, whenever you pass away? I like to have a couple of different levels there. Who's going to receive your property? Now, if all your family is alive, so you're the only one who dies, wife is still alive, you're probably, very common plan, you're leaving everything to her or vice versa. But think about the next level. Both of you die at the same time, then where does it go? Right? Very common, well, I'm going to leave it to the children. All right, that's great. I hate to make you think about this, but daughter is taking you and your spouse out to dinner. All three of you are killed in a car accident. Then where does her share go, right? Then it can pass down to the grandchildren, for example, okay? Or it can pass to the church, right? Or it can pass to whoever you want it to pass to, right? But you just got to be thinking through those particular ones. Those of you that might have minor children, and if you're grandparents and now find yourself taking care of minor children, who are going to be the guardians of those children? That's the big one when I'm talking to young couples. That's the big one we spend a lot of time with. Who's going to be the guardian, you know, with things, okay? So I would encourage you to have a will. If you don't have a will, there is a whole series of statutes. It's called the intestate statutes, which deal with where things pass for people who don't have a will. Okay? There are 13 levels of that. Okay? My stomach's starting to hurt right now. I had to memorize that in law school. And the very last level is the state of South Carolina, if you can't find, you know, anybody else. Okay? I've never had that happen where we couldn't find, you know, anybody. Okay? But it can be so if you die and you're married with children, it all doesn't go to your wife. Okay? 1/2 goes to your wife, 1/2 goes to the children. Okay? And just kind of think about that a little bit. You and your wife own a piece of property without the rights of survivorship language. Okay? So you own 50%, wife owns 50%. Okay? You die without a will. Half of your 50% goes to the wife. We're doing junior high fractions right now in our minds. Okay? Half goes to the wife. That means that the wife now owns 75% of the house. Okay? Children own 25%, half of a half. Okay? And then that 25% gets divided up amongst however many children that there are. 2 children, 3 children, 4 children. Okay? So that can be a little bit of a mess, and then we have to try to do some things to try to clear that up to get all that into the wife's name. All that would have been resolved if you had a will that says I leave everything to my wife, for example, okay? A will, everything in a will though, has to be probated, okay? You have to go to the probate court with that. So let's talk about that probate process just for a little bit. Somebody dies, they take, the personal representative takes the will to the probate court. My wife's died, my husband died, my child's died, whoever it is has died. They then have you, in Dorchester County, you have to attend a little seminar, okay? Berkeley and Charleston, they do it a little bit differently. You will fill out an application, you get to be appointed as a personal representative. You got to run a little ad in the newspaper for creditors, okay? You've got to list what is called an inventory and appraisement of the property that the deceased person owned. That can be fairly general. You can say real estate, you can say car, you can say, you know, bank account. You don't have to say 22 forks, you know, for example, or 82 pairs of shoes, okay? All right? Yeah, you got 82 pairs of shoes, okay? Some of you do. All right, so you know, Sam, don't say anything, brother, okay? Yeah, just be quiet. You start talking back there, brother, you are going to need me, okay? You will. Yeah. So you list the inventory and appraisement, you know, things. The probate court is going to charge fees based on the value that goes through their probate court. Now, South Carolina, the fees aren't terrible, but they're still fees. Okay? You're going to have to pay them. Creditors have 8 months in order to file claims against probate assets. So whenever somebody comes in and they've lost a loved one, well, I'm telling them almost at the very beginning, I just want you to plan on a 1-year process. Because we got to do some work at the very beginning. We got 8 months for creditors to make claims. And then we got to do some work at the very, very end, okay? All right, so that's kind of the probate process. So you have a will, you're going to run through that process, right? Let me jump into real quickly revocable trust, okay? That's one of the other items. Here's the concept behind a trust. If you have special needs children, you probably need a trust, because even after you die, you're going to need to be taking care of that child. Okay? Maybe they're not special needs, but maybe they just don't handle money very well. Okay? And if that's the case, you might need a trust as well, because you leave them $100,000, they're not going to have it 3 months from now. Okay? So a trust could help with that. One of the main reasons, though, people come to me for trust is they want to avoid probate. That's that word we were just talking about. Okay, they want to avoid that process. Here's the concept. We set up, and I'll just use my name, we set up the Reeves Family Trust. Okay? We take all of our assets, our house, our cars, our bank accounts, whatever it is we have, we put them into the trust. Okay? Then whenever you die, Jimmy Reeves dies, there's nothing to probate. Why? Because I don't own anything. The trust owns it. Okay? The trust then has stipulations and instructions. This is how things are to be distributed out. Okay? And then the trustee, you have to name a trustee, then distributes out that property. Okay? So that distribution under a trust can happen really about as fast as the trustee can make it happen. Okay? So in other words, 30 days, 60 days, 90 days, right? Those are all non-probate assets, okay? They don't go through the probate court. Wills and trust. I do a lot of wills, I do a lot of trust, okay? A lot of people don't need a trust, okay? And I talk about, well, that sounds so good what you just described. It is good, and it's very common, it's a great tool. However, if you're trying to avoid probate, okay, remember your non-probate transfers that we talked about earlier, okay? Putting the or on the car, changing the deed, having the joint checking accounts, all these kinds of things. So it's very common that whenever someone dies, my father died 15 years ago, there wasn't anything to probate. Why? Because we had it all set up as non-probate transfers. okay? So he still had a will, but we also had the non-probate transfers, to do it. The disadvantage on a trust, candidly, has to do with the legal expense in setting it up. It is more expensive to set up, is more time consuming to set up. There's more effort on your part to set it up. I'll just tell you real because I wonder if this question is going through your brain. Most couples that come into my office, we can do something with wills and powers of attorney and maybe even take a look at their deed, $1,000 or less, okay? Trust, you're probably in the $4,000 area, okay? So you're talking about, a good bit more money. So sometimes people will say, Jim, my family can't handle that probate, okay? I love them, they're wonderful people, but they can't do that, all right? Okay, great, we need to set up a trust, all right? You pay me the money now, let's do the work now so they don't have to do anything later, okay? Other people will say, why in the world am I spending $4,000 on a trust? I'm leaving my children all the money. They're getting free money anyway, all right? I'm going to let them deal with it, on the end. That's great, okay? So I don't lose sleep when people say, I want to do a trust or I want to do a will. Will is a great way of going about it. Just make sure you do your best to set up the non-probate transfers. Yes, you are going to have to do some probate, but maybe not a whole lot, depending on that, okay? All right, I'm looking at the clock. It says 9:40, all right? So I'm running out of time here. So let me and also just to give you a little back, the last couple of sheets in here, this is a state planning probate information sheet. This is a sheet of information that I provide to a lot of my clients, and whenever they're doing wills, has a lot of information about where do I keep my documents, for example. Okay, that's a good question, with thing. There's also just kind of general information about some, where do you bank, who's your CPA, who's your life insurance agent, okay? What funeral home do you want to use? All these kinds of things. In other words, it's not going to surprise me. I'm just going to tell you, with the Jimmy Reeves household, my wife takes care of the personal finances a great deal, okay? She says, Jimmy, you make the money and I'll spend it, okay? Thank you, love, okay? All right? But she knows passwords that I don't know, okay? Because I don't use those passwords. Well, I may need to know those passwords, okay? So we got a little system set up to where I can find that information. All right. That's a lot. Yes, sir, go ahead.
You and I have dealt with this probably 3 or 4 times over the years about people wanting to give a gift to the church upon their death, but they don't talk to their family at all about it. It creates a lot of issues. Can you maybe touch on that?
I just encourage people to be open books and tell people what they're doing, okay? And to talk with their family. And sometimes I get, well, they're not going to like what I have to hear. I understand that, but I think you ought to tell them about it, because I have seen situations with this with Miles Road. People left Miles Road, money, right? That's where they wanted it to go. They didn't tell the family. The family gets all upset, okay? What do you mean the money's going to the church? Well, that's exactly, where it's going. And of course, Pastor Palmer has to then, deal with that and handle that. And I know he's actually given, Miles Road got money they didn't even know they were getting, okay? All right, so he actually kind of gave some money back to the family to kind of help with relationships and all those kinds of things, okay? You also, you need to tell your children why you're doing certain things. If you got 3 children and the youngest is a local child, and you make that youngest the personal representative, okay? Well, then you die, okay? The oldest shows up and says, what do you mean my kid's sister is in charge of things, okay? Or then I've also heard this, did mama love them more than she loved me, okay? I mean, I've heard it in my conference room. Did mama love them more than they loved me? No, they didn't. They loved you, okay? The problem is that she was local. She thought it would be easier for her to do it than for you out in Wyoming someplace. So I'm a big believer. Thank you, Pastor, for bringing that up. Talk to your family.